Good afternoon, ladies and gentlemen, and welcome to this first webinar of the East Africa Law Society. Today we are looking at training. It's a digital training around privacy in an enterprise context. We have in our midst a very experienced practitioner in this area, who will guide us through this topic. It's a series of 3 sessions that you complete the 3 sessions so that we can then give you or issue you with the certificate to show that you have a relative level of expertise in this particular area. And so if we see you today, we are expecting to see you in the next 3 sessions. My name is David Sigano. I currently work at the East Africa Law Society, as you might already know. I'm not going to moderate today's session. It's going to be moderated by a lady who has relative experience in this area also. Without taking much time, I'm going to call Ms. Annabelle Moine to guide the session. She'll then call the presenter, who will take us through the session today. Thank you.
Thank you, David. Good afternoon to you all. My name is Annabelle Moine, and I will be the moderator for today's session. The way the session is going to run is that I will introduce our speaker for that day, who will give his presentation, and we will then go into questions. I see a few hands raised already. I ask that we first let the speaker, our speaker, share, and then maybe we can get into questions. But if your question is really burning, please type it in the chat section. I will be monitoring that section, and I will note down any questions that are available. David, I don't know if I should give maybe a context of what we'll be speaking about today, or maybe will what you shared suffice?
Annabelle, you're the moderator today. You decide what to do.
Okay. So I'll just give maybe a brief context for us to get a better picture of what we are discussing today. Our workshop, which is a 3-part webinar, and like David mentioned earlier, is a workshop on privacy. Privacy in an enterprise context. Basically, with data privacy and protection, it's a rapidly growing area, as we may all know or have noticed, and mostly because there has been an increasing need for access to data by businesses for business purposes, and also because the world is now more digital because of recent events, COVID and all other aspects. Most of what we do is virtual and digital. So there has been a need to protect personal data and information, to ensure privacy. Very many countries, both local and internationally, have established laws governing that aspect. And in East Africa, I know so far Uganda, Kenya, Burundi have primary laws governing data privacy, and I think Rwanda is also coming up with something. Internationally, the most predominant one would be the EU's General Data Protection Regulation, which governs the same. So for today's session, our first session, which is the first of 3, will be an introduction to privacy program management. And this session is going to be, our guest speaker for the session is Mr. Lawrence. Mr. Lawrence Dinga, and I will read briefly his profile, and then I will ask him to take over. Mr. Dinga is a seasoned international cybersecurity consultant with wealth of experience and expertise in cybersecurity, privacy, and digital forensics capacity building. He trains legal professionals, including lawyers, prosecutors, magistrates and judges in the area of cybersecurity, cybercrime, electronic evidence, and digital forensics. Lawrence is an approved consultant with the Cybercrime Program Office of the Council of Europe on law enforcement and judicial training in cybercrime and electronic evidence. Lawrence is also a consultant for the European Union Agency for Law Enforcement Training on cybercrime attacks against information systems and law enforcement technologies, forensics, and other specific areas. He's a digital forensic expert witness in court and has testified in many cases of cybersecurity and digital forensics. Lawrence holds a Master's in Science in Forensic Computing and Security from the University of Derby, England, an LLM in ICT law from the Open University of Tanzania, and a diploma in law from the Kenya School of Law, and is also a certified information security system security professional. Lawrence has extensive IT consultancy and cybersecurity capacity building experience in the EMEA region and is the former and chief executive officer of Managecom Systems Limited, a leading cybersecurity and digital consulting service provider in Africa. Managecom Systems Limited strives to deliver state-of-the-art cybersecurity and digital forensics products, solutions, and services to individuals, corporate entities, and law enforcement across Africa. You're welcome, Mr. Dinga.
Thank you very much, Annabelle. Good morning, ladies and gentlemen. Good afternoon, sorry, ladies and gentlemen, and I welcome you to this webinar on privacy in an enterprise context. Let me just share my screen. I hope everyone can see my screen.
We can.
Yeah. Thank you very much, Annabelle, again. As you've done a good introduction of myself, I think I'm not very new to many participants in this webinar. We've been carrying out this kind of webinars in the year 2020 and year 2021, except that we've been more on the cybercrime, electronic evidence, and digital forensics in a legal context. Now, privacy is also something that is an area which is coming up very rapidly, and we've seen so many countries enacting legislation about privacy. So we wanted just to look at this privacy from an enterprise context. How do you handle privacy? So this is a three-part series, and part one, we are going to look at privacy program management and governance. You'll find that as we go along, we might not exactly follow what the flyer is, but eventually we are going to cover all the content that is supposed to be covered in this three-part webinar series. So today we are just going to look at privacy program management and governance. That is privacy in the context of an enterprise. Yeah. Now, just a moment. This thing is. I'm trying to see how I can disable this. I'm struggling how I can. David, how do I remove this from the top? No. Right. Good. Yeah. So yeah. So let's look at privacy. So when we talk about privacy, and I think privacy is all over the world is considered a fundamental right. Privacy is considered a constitutional right. Privacy is considered a human right. And you find that privacy is enshrined in many legal instruments, including Kenya's constitution 2010 in Article 31. However, apart from that, we can see that privacy is something that is found in many international treaties. Like we are talking about the International Covenant on Civil and Political Rights, the European Convention of Human Rights, the European Charter of Fundamental Rights. Privacy can also be is also enshrined in many constitutions. The one which I liked most is the Dutch Constitution, which has got 3 articles just talking about privacy. You find that in that in the Dutch Constitution, they talk about Article 10, which is talking about the right to privacy and data protection. That Article 11 is talking about right to integrity of body and mind, and the right to Article 12 is talking about the right to privacy of home, and that Article 13 is talking about the right to confidentiality of correspondence and communication. Also, if you look at even the German Constitution, we have Article 2, which is talking about the right to self-determination. And from the US point of view, you find that they have the Amendment 14, which is talking about protection against unwarranted searches and seizures. So if you can see that from the historical point of view, privacy is a fundamental right, and it protects citizens from intrusions into their private lives by the government. That is the right to be left alone. So when we talk about privacy, we are talking about privacy from the physical privacy, as well as the data privacy. Now, going back to Kenyan Constitution 2010 on Article 31, we find that it says that privacy has, every person has the right to privacy, which include the right to have their person, home, and property searched, their possession seized, and information relating to their family and private affairs are necessarily required or revealed, and the privacy of their communications infringed. So you can see that those 4 bullets, A to D, if you can see, A and B is more about physical privacy. But if you look at C, that is information relating to their family and private affairs, is more of a data privacy or information privacy. If you look at the protection of their communication, that is more of information privacy. So when we talk about privacy from the enterprise context, then privacy involves the protection of personally identifiable information. That is the PII. That is what the privacy is all about. Let me just remove this also. Hide. Yes. Yeah. Okay. So from an enterprise context, privacy involves the protection of personally identifiable information, which means that we are talking more about personal data when we are talking about privacy. Now, what is personally identifiable information? Now, personally identifiable information is any information that can be used to identify a subject to whom such information relates. Or it is that information that might be directly or indirectly linked to a subject. So if you have something like a name, your picture, and anything that can be able to identify you, that is personal information. That is personally identifiable information. So when we talk about privacy in the context of personally identifiable information, we are talking about two main components here. We are talking about the collection, the proper collection, handling, management, and use of personal information. At the same time, we are also talking about protecting that personal information. So privacy in the context of PII entails the proper collection, handling, management, and use of personal information, and also the protection of that personal information. So the first component is what we call data governance when we talk about privacy. So what is data governance in privacy? Now, data governance is a collection of processes, roles, policies, standards, and metrics that ensure that effective and efficient use of information in enabling an organization to achieve its goals. So you find that we are talking more about the policy here when we're talking about governance, more about policies here. Policies, we are talking about processes, we are talking about standards. So that is the first component of privacy. The other component of privacy is about security, protecting that information. How do you protect that information from bad guys? So when we talk about privacy, cybersecurity component of it, so cybersecurity is actually the art of protecting networks, devices, and data from unauthorized access or criminal use, and the practice of ensuring confidentiality, integrity, and availability of information. This is a definition from the Cybersecurity and Infrastructure Security Agency of the US. So basically, privacy is about the personally identifiable information, the PII, and it has got two components of it. That is the proper collection, handling, and management of that personal information, which is the data governance, and the protection of that particular information, which is more on the cybersecurity. Now, when collecting, processing, and protecting PII, now, when you are collecting and processing PII, it has to be carried within the limits of applicable and regulation, and must follow fundamental privacy principles. We are going to see those principles towards the end of this presentation. But basically, we are talking about making sure that when you are collecting that information, that personal data, it has to you have to adhere to certain laws, applicable laws and regulations within that particular jurisdiction. Then when we talk about protection, then we are talking about the confidentiality, the safeguarding of confidentiality, integrity, and availability of that information, or that PII. Now, when you are, this is what we call the CIA triad, the confidentiality, integrity, and availability. Now, when you are doing that protection, you have to make sure that you apply the risk management processes that gives the confidence to the interested parties that the risks have been adequately managed. Because when you are trying to protect an information or that personally identifiable information, it depends on the value of that information. Now, the value, given the value of that information, the means of controls that you are going to use to protect that information will differ according to the value of that information. So what is confidentiality? It is the property that the information is not made available or disclosed to unauthorized individuals, entities, or processes. Now, confidentiality simply means that keeping the secrets secret, which means that somebody who's not supposed to see that information is not allowed to see that information. That is basically about confidentiality. So confidentiality is not only about the PII. Confidentiality can also be about information that is critical to the organization, and only certain people should be able to see it. But when you talk about confidentiality from the point of view of personal information, personally identifiable information, that is when you are talking about privacy. Now, integrity, on the other hand, is the property of accuracy and completeness. Integrity from the security point of view means that that data that you are using in the enterprise to make the decision, that data has not been interfered with. And it is, you believed it to be accurate. You believe it to be complete, which means that if I keep data in a system and I want to use that data, and I look at my inventory or paper inventory, I find that in the inventory I have 5 widgets, but in the computer system I have 6 widgets. That information is not complete. So you cannot use that information to make decision. You only use that information to make decision if that information is complete. So integrity deals with the completeness of information. It deals with the accuracy of information. Availability is the property of being accessible and usable upon demand by an authorized entity. Mark here is not just available to anybody, it's available to an authorized entity. So when you are availing that information, make sure that that information can only be available to the authorized entity. There are ways now which now get into security, how you can be able to implement the confidentiality, integrity, and availability from the information security point of view. However, we are not going to look at that at this moment. So why privacy program management? Because we know we are here, remember, we are talking about privacy in the context of an enterprise. So which means that we are going to put in processes and technologies and any other thing to help us protect this information and help us to collect this information, process this information in a valid manner. So that is why we need a privacy program management within the organization. So what is a privacy program management? It is the structured approach of combining several disciplines into a framework. Mark this word, it's a framework that allows an organization to meet legal compliance requirements and expectations of business clients or customer while reducing the risk of data breach. Now here, there are things that we need to note here. It's a framework, which means that you are going to put, this framework has got other bits that you have to put together that to form this framework. So what does this framework do? This framework will help the organization to meet the compliance requirements. Remember, when we are introducing privacy, we say that the collection of that data must be done within the applicable laws and regulations. So this framework will help the organization to meet the legal requirements and expectations of business clients, because the clients and customers have entrusted you with their data, and they want to know whether that data is properly taken care of. So you, by putting a privacy program in place, you are making sure that you are taking into consideration the expectations of the clients and or customers, while at the same time reducing the risk of data breach. The data breach is expensive. You've seen in the newspaper, in the news headlines, each and every day, data is being breached. A company suffers data breach, and when they suffer data breach is an expensive affair. So putting on in place a privacy program within the enterprise will help you to reduce the risk of data breach. So a well-managed privacy program can serve many functions. For example, if you put a well-managed privacy program, then you are promoting consumer trust and confidence. Remember, consumers have entrusted their data with you. Now, I can give you an example of a bank and a financial institution. Now, in most cases, you find that in the last couple of years, both in Kenya and in East Africa or in Africa or worldwide, you find that many financial institutions are hit. And when they are hit, they don't talk about it. Why? Because they want to protect the trust and the confidence the consumers have in them. So by putting in place privacy program, you are going to make sure that you are the consumers have, you can win the trust and confidence of your consumers. Another another function is enhancing brand reputation. You know, you are selling your brand, and brand is if the reputation of your brand is damaged, then that is the end of your business. That's the end of that enterprise. So it is important to have a privacy program management in place to make sure that you enhance your brand reputation. Also, maintaining the quality and value of data. Now, the value of data depends on the quality of that data. So if you have a privacy program management in place, then it will help you to maintain the quality and the value of data that you are processing. Also, safeguarding data against attacks and threats, because we talked about privacy and we say that the privacy are more about the data governance and the protecting of that data. So if you'll put in place controls that are going to safeguard that data from attacks and threats. So this is all coming under privacy program management. Also, it will ensure that you meet the expectation of business partners and clients and service providers. If you have in place a very good and well-managed privacy program, then you find that your business partners, your clients, your service providers are going to be happy with you. What are some of the key drivers of privacy program management? One is data governance. Now, because you keep on collecting and using and storing the personally identifiable information, you need to set up formal programs to manage that information. Otherwise, you'll have a situation of information glut, where information is everywhere, and that information is not governed in a way that can be able to make help the organization to make a decision. Because you find that when we talk about basing our decision on information, we start with data. Now, data put in context becomes information, and information in context becomes the knowledge. So that information is what you use to make the business decision. So if you have to have a proper decision making using your information, then you need to put in place data governance. Now, the other aspect is globalization, which means that technology has allowed businesses to rapidly increase their global reaches and interface with international customers, often without a physical presence in jurisdiction that they serve. So you'll find that this has also made it a requirement that we have to have put in place a proper privacy program management in place, so that we can be able to adhere to these other legal or regulations from other jurisdictions in which we do not have presence. Increased regulations. We find that as collection, use, and storage of PIIs has grown in many countries, countries throughout the world has turned their attention to regulating those activities. And we were just talking about in Kenya, we have the Data Protection Act 2019. In Uganda, we have the Data Protection Act. I think Rwanda is also coming up with one. Tanzania, I think, has not, I don't know the status in Tanzania, but more so if you look at our model data protection is the GDPR, General Data Protection Regulation from the EU. Now, the aspect, key driver is growth and vendor networks. Now, the growth in use of vendors has increased the need to manage an extended network of suppliers, contractors, consultants, and third parties with access to corporate data. Now, people like you, lawyers, you have access, maybe you can be given access to information belonging to your clients. So they have, for you to access that information and make sure that that information or data is safe, then the client, your client will have to put in place a proper, a well-managed privacy management program in order to make the data safe. Otherwise, if we just leave everybody accessing data without proper, a well-managed privacy program, then we can lose the value of that data. The other thing is increased sensitivity, in which case with the increase in data collection, the threats to that data has also grown. The proliferation of data breaches, incidents, and social profiling has made employees, consumers, and customers sensitive to the risk associated with authorized disclosure of personal information. So you find that that increase in sensitivity, profiling, I don't know, to profile the employees. This makes that data privacy program be of use to the organization. Now, within the organization, we have somebody called the privacy program manager. Now, the privacy program manager, it depends on the organization, how that organization is governed. Now, you'll find that in an organization, you can find that they have chief privacy officer, who can be a lawyer or who can be a technical person. Now, so, because this is something that is very new within the organization, you'll find that each organization might have a compliance department, and that compliance department is headed by the internal legal department. Now, in that case, you'll find that when they are recruiting a privacy manager, they'll tend to look at the legal professionals to head that department. However, sometimes you find that the privacy function of the organization is given to the information security, because privacy and information security work in hand. In that case, you'll find that the privacy program manager will be more of a technical person to manage that particular function. However, the responsibility of a program manager will include things like identifying privacy obligations of the organization, because each and every organization which is handling personal data has got the obligations to observe. So that is the work of the privacy program manager, to identify those obligations of the organization, the privacy obligation of the organization. They also need to identify business, employee, and customer privacy risks. What are the risks that are involved within the organization when we are talking about privacy? Their work is also to identify existing documentation, policies, and procedures. They also need to create, revise, and implement policies and procedures that affect positive practices and together comprise a privacy program. So you'll find that in an organization setup, this aspect of this function of privacy program management is left for this guy called the privacy program manager, and it depends on the setup of the organization. I say that if the function of privacy is being given to the legal department, then you'll find that the privacy manager will tend to be a legal guy. If it is on the security, then you'll find that this person tend to be a technical person. However, these are some of the functions, these are some of the responsibilities that this person is supposed to look at. Now, when you are building a privacy program, you have to start with what we call the privacy governance. Now, privacy governance is actually the components that guide a privacy function towards compliance with privacy laws and regulation and enable it to support the organization's broader objectives and goals. So here, what you're talking about is that privacy program is an overarching program. But for that program to work, you need to put in place this privacy governance in place. And what are some of the components of privacy governance? We are talking about creating the organization privacy vision and mission statement, because before you put in place privacy program, you need to identify what are the vision of that privacy program. What is the mission statement? And this must go hand in hand with the mission and vision of the organization. So you also need to define the scope of that privacy program, because if it is not scoped, then you'll find that you can do more than is expected, or you can not be able to meet your expectation because it is scopeless. So it is important that you have a scope. You have to scope the privacy program. Now, the governance also includes selecting an appropriate privacy framework. Now, when we talk about a privacy framework, here we are talking about you cannot be able to reinvent the wheel, because in the around the globally there are framework there are frameworks that have been put in place. The frameworks that have been put in place that you can just use and adopt it to your organization. The component also includes developing the organization privacy strategy, and then after developing the strategy, you also need to structure the privacy team. Who are the people who are going to be managing this privacy program? Now, when we talk about privacy vision and mission, it should be aligned with the organization broader purpose and objectives. So the privacy privacy program management will not operate on its island within the organization. The vision and mission must align with the organization broader purpose and objectives and business objectives. Now, the vision is typically composed of a few short sentences that succinctly describe the privacy reason d'etre, which means that what is the main objective of this privacy program which we put in place. So our privacy mission statement describes the purpose and ideas in just few sentences. It should be take less than 30 seconds to read. Which and I got one from the Stanford University missions, their privacy mission. It is just a short sentence, just enable Stanford to navigate a dynamic future in privacy through transparent, ethical, and innovative uses of personal data. So it is something that should be shorter, is something that somebody should read and see what is the vision, what is the mission from that particular statement. So it is for you to come up with a privacy program management, you need to start with a privacy vision and mission. And that privacy mission and vision must be aligned to the organization's broader purpose and business objective. It is not something that is going to operate on its own. It has to be aligned to the broader purpose and business objectives. Now, defining privacy or program scope, because you need to have a scope for your privacy program. You need to define that scope. So for you to decide define that scope, there are two things that you need to take into consideration. First of all, you must be able to identify the personal information collected and processed within the organization. Whatever your area that you're dealing with, what are the personal information the organization collects, uses, stores, and otherwise processes. So you need to have that inventory. And we are going to we'll look at that when we are looking at data assessment. But first of all, you need to have that inventory. You need to identify the personal information collected and processed by the organization. So you can ask yourself such questions like, who collects, who uses, and maintains personal information relating to individual, customers, and employees? What type of personal information are collected, and what is the purpose of collection of that information? I need to ask questions like, where is that information collected physically stored? Is it stored within the organization? Is it stored in the cloud? To whom is the data transferred? If data is to be transferred from one jurisdiction to another, who is it transferred to, and what are the methods of transferring that data? How long is data retained and how is it deleted? If the data is collected, how long is it supposed to be retained? And if it has outlived its usefulness, how is it supposed to be deleted? So what security controls are in place to protect that data? So if you have this, you've identified the personal information collected and processed within the organization. That will be one step towards defining your privacy program scope. You just make sure that you know what personal information the organization collects, the organization uses and stores and or processes that information. The second aspect in defining your scope is identify in scope privacy and data protection laws and regulation. Now, this entails the identification of the organization privacy obligations related to that data. Now, this, for example, if you are an international organization operating in Kenya, now you have your staff who are EU members. Now, so which means that when you're operating and you're collecting personal information, then what are some of the data protection laws and regulations that relate to you? What are your obligations within those data protection legislation? So, for example, I'll just give you an example. If you are an international organization operating in Kenya and you have EU staff, members of EU are in your staff, then you find that you need to adhere to maybe Data Protection 2019, the Data Protection Act 2019 will affect you. The GDPR will affect you. So that is why it is important when you are defining your privacy program scope, you need to identify in scope privacy and data protection laws and regulations that you are obligated to adhere to. Now, you find that most global organizations are subject to many data protection. I've just talked about that. Some personal information collected and processed may also be subject to more than one regulation. For example, if you are collecting health information. Then you have health regulation to adhere to. So you find that if you are an organization which is dealing with health, then you'll find that you have the health regulation to adhere to because you are collecting health information. You also have, maybe if you are operating in Kenya, you also have the Data Protection Act 2019 to adhere to. If you are in a financial institution, you may find that financial transaction may be subjected to additional financial reporting regulation. So you need to adhere to that particular regulation, as well as the main data protection regulation. So before in identifying or defining your privacy program, those two things must be able, you must be able to accomplish those two things. You have to be able to know which data is being collected, processed, and used. And also you need to know what privacy and data protection laws and regulation that you are obligated to adhere to. So you need to determine the true scope of your situation before you come up with a program, privacy program management. Now, what is the successful approach if you find yourself in this situation? First of all, you need to understand the end-to-end personal information data life cycle. Any data is created, data is used, data is discarded. That is the data life cycle. So you need to understand what is the life cycle of that data. How is it created? How is it used? How is it discarded? Then you'll be able to understand the scope of your privacy program. You also need to take consideration of the global perspective in order to meet legal, cultural, and personal expectation, especially if you are a global organization. If you are you look at the information globally, you need to look at the cultural aspect, you need to look at the legal aspect, and you also need to look at the personal expectation. Also, you need customizing of privacy approaches from both global and local perspectives, because you'll find that you are required to observe more than one regulation in your area of operation. Awareness of privacy challenges, including translation of laws and regulations and enforcement activities and processes. This is also something that you need to take into consideration. Also, you need to take into consideration for a successful approach, monitoring of all legal compliance factors for both local and global markets. Now, we talked about a privacy framework or a privacy compliance framework. We say that it is a structured set of guidelines and practice that bring together regulatory compliance requirements that apply to that particular organization and business processes, policies, controls that are necessary in order to meet these requirements. So a privacy compliance framework provide a structured way of managing confidential data in such a way that the organization is able to comply with often complex laws and multi-jurisdictional basis. Now, what I said here is that compliance framework is something that you do not go and reinvent the wheel. There are certain compliance frameworks and standards that are out there that you can take into consideration and adopt them to your organization. Because if you look at a compliance that we are going to look at, you'll find that they will be addressing areas that your privacy program management needs to address. Things like governance. They will address things like risk management. They address things like compliance objectives. They also address things like privacy principles that we are going to look at towards the end of this presentation. You also address policies. You address procedures, controls, and record. And that is why when at the end of this series, we are going to look at some of the tools that you can use to implement your privacy program management, because these are not things that you can be able to successfully do manually. So you can have these frameworks in place, or a tool that you are going to have in place will be based on a framework that is actually in place that you can just adopt to your organization. Now, some of these frameworks are as follows: the ISO 29100 privacy framework. Now, this framework provides a high-level framework for protection of personally identifiable information within ICT systems. Now, remember, before I started this, I didn't tell you, but what I said, that we are looking at privacy from the enterprise context. Now, in this place, during this session, we are not going to look at any legislation that has been enacted globally or within your jurisdiction, things like data protection laws. No, we are not going to look at that. We are just going to look at how do you treat privacy from the enterprise point of view. And remember what we talked about, that privacy, we are talking about data governance, and we are talking about cybersecurity. So if we have a framework in place like ISO 29100 privacy framework, which is protection of PII within ICT systems, which means that when you are implementing this framework, you are implementing it in your ICT system to make sure that you take into consideration the protection of personally identifiable information. It is intended to help organizations define their privacy safeguarding requirements related to PII within the ICT environment by specifying common privacy terminologies. Now, these common privacy terminologies, we can't look at them because of time, but when I talk about privacy terminologies, I'm talking about things like, if I say the data subject, if I say the privacy, the controller, data controller, if I say about data processor, if I talk about the privacy principle, what is it? What am I talking about? Now, these are some of the terminologies that this framework is coming out clear, specifying when you are implementing this framework. Now, it's also it also defines the actors and their roles in the processing of PII. For example, who are the actors in the privacy arena? Here we are talking about the PII principle, the person who or the data subject. We are also talking about the privacy controller. We are talking about the privacy processor, things like that. So it's also described the privacy safeguarding requirements, and also it references non-privacy principles that we are going to look at the end of towards the end of this presentation. So this framework is intended to enhance the existing security standards by adding focus relevant to processing PII. So within the organization, you might have your ICT system, which you're using to provide to protect the data or to process the data. So if you apply this framework within your ICT system, it's just going to give you controls that you are going to implement to ensure that the processing of relevant processing of PII is taken into consideration. Now, this framework is used to aid in the design, implementation, operation, and maintenance of ICT systems that handle and protect PII. It is also used to spur innovative solutions to enable protection of PII within ICT system. Also, it is used to improve the organization privacy program through the use of best practices. So it is is a framework that you can go and do some research on and see how it can fit within your organization. It is applicable to natural persons and organizations involved in specifying, procuring, architecting, designing, developing, testing, maintaining, administering, and operating information and communication technology systems and services where privacy controls are required for the processing of PII. So this is one of the framework that you can adopt to your organization instead of starting reinventing the wheel. The other one is ISO 27001 privacy framework, security framework. This is not privacy framework, this is security framework, this ISMS. Now, this is an internationally recognized management. So that title is wrong. It's not ISO 27000. It's not a privacy framework, but it is information system, information security management system framework. Now, you remember when we talk about cybersecurity, we talked about how you can protect the confidentiality, availability, and integrity of data. And if that data is relating to natural person, then it becomes the privacy. So ISO is not actually geared towards the privacy, but is more geared towards the protection of information within the organization. So it is an internationally recognized management systems standard for information security management, any information. So it describes the requirements of information security management system based on established best practices, and it is sector agnostic. It does not favor any technology or solution and can be used by organizations of any size. It sets out requirements for what must be done to secure information, but provides organization the room to determine how they implement the requirements to meet the organizational objectives and risk appetite, which means that we say it is sector agnostic. And also it does not dictate what technology that you are going to use, but it just gives you the best practices that you can use any technology to implement. So this framework for information security can also be used to achieve accredited external certification. We've seen many organizations are now going for ISO 27000 certification because they want to ensure that their information within the enterprise is managed properly. Now, there's also the ISO 27701. Now, ISO 27701 is a privacy extension of ISO 27001. It establishes the additional requirements and provides guidance for safeguarding of privacy as potentially affected by personal data processing. So it is just an extension on top of the ISO 27001. And it can be, so if you look at, right now we have ISO 27001 version 2013. Now, if you look at that particular standard, you'll find that the ISO 27001 just reinforces that standard, but is now putting additional requirement for privacy. That is all about ISO 27001. So as we can see that as the overlap of privacy and security regulation increases, so do the calls for new ways for these two teams to collaborate and communicate more effectively and use common tools. Now, I talked about the information security team and the privacy team. You'll find that these people need to work together because privacy, as we are going to see later in the presentation, privacy and security, information security, most of it overlap. And there are some certain areas where they have disconnection. So it is important that the team that is working on privacy and the team that is working in information security, because one is about the collection and use, proper use and processing of information, and the other one is protecting that information. So they go hand in hand. They go together hand in hand. Now, technology is needed for the maintenance and continual improvement of privacy in a privacy information management system in accordance to ISO 27701, as well as planning and implementation of global privacy laws and frameworks. So this is a framework that can be, you can implement within the organization, but remember, it is something that is working on top of the ISO 27001, which is an SMS or security management system. So how do you develop a strategy for privacy program within the organization? So privacy strategy, first of all, is the organization approach to communicating and obtaining support for privacy program. This is not something that you can do as one department. You need to do this as collectively as an organization. So for privacy to work, for you to achieve what it is intended to achieve, then you need to make sure that you obtain the support for that program from the executive and everybody from the organization. Otherwise, you'll find that your program will be half-baked. So the strategy process involves various stakeholders, and they must take into consideration the business alignment. It must take into consideration the data governance. It must take into consideration procedures for handling inquiries. So this is how you develop the strategy. You must make sure that the strategy is an all-encompassing strategy that is taking care of each and every single important department within the organization, because everybody has a role to play in protecting personal information within an organization. That information that is being collected, that is being used, that is and how it is disclosed. Everybody must be a party to that. For example, if you are talking about salesperson or sales personnel, they must secure business contact data and respect the choices of those clients. The clients that they are bringing into your organization, the customers, they have these salespeople must be able to respect their choices. Because remember, for example, with the Data Protection Act 2019, the Kenyan Data Protection Act, there's a section which talks about if somebody needs his data, then that data should be provided when that data subject requires them. So it means that you have a choice. The data subject has a choice on how they want their data to, or their information to be processed. So that must be taken into consideration when you are doing your strategy. People like developers within the organization must incorporate effective security controls and create solutions that require collection or use of only data necessary to accomplish the purpose, which means that you should not collect data, which is the system that you are developing to collect data should not be collect data more than what they need to collect. Now, once you have that, then the next step that you need to do is to identify stakeholders and internal partnership within the organization. Remember, we are talking about privacy within the on an enterprise context. So once you have your strategy, you need to identify the stakeholders and internal partnership. Now, here we are talking about who are going to be supporting your privacy program. Now, building and gaining consensus from members of the organization management on privacy as a business imperative must be done in stages, which means that you cannot do it at one step. So you need to conduct informal one-to-one conversation with executive within the organization who have accountability for information management or security or risk or compliance or legal decisions. Now here I'm talking about the privacy manager within the organization. You've been given the task of crafting a privacy management program. So how do you do this? Once you have your strategy, then you need to identify the stakeholders and internal partnership. These are the people who are going to support your program. So you need to have one-to-one organization or one-to-one conversation with people who are concerned with the information management. people who are concerned with security, people who are concerned with risks, to see how they perceive privacy within the organization. Now, the executives, the managers, and internal partners will each play a role in the development and implementation of this privacy strategy for the privacy program. So from this conversation, you should be able to know which executive will serve as the program sponsor or champion of the privacy program. In that case, you'll be able to succeed. Otherwise, if you are not able to get these guys together to understand their thoughts about privacy, then privacy program management project will fail. Some of the best practices you need to adopt is, for these guys, you need to become aware of of how others treat and view personal information. If there are some people who do not even know about PII, you need to talk to them. You need to understand their use of the data in a business context. You also need to assist with building privacy requirements into their ongoing projects to help reduce the risk. You also need to offer help to help staff meet their objectives while offering solutions to reduce risk of personal information exposure. And you need to invite staff to be part of the privacy advocacy group to further privacy best practices. So these are some of best practices that you need as a privacy program manager. You need to take into consideration to make sure that your privacy program management can take shape within the organization. If you do not understand people within your organization, then you will not be able to roll out your program, because people do not understand what the context in which you are placing the personal information. Now, after that, once you've identified the internal partnership, then you need to conduct a workshop for the stakeholders. Remember that all the stakeholders are not on the same page. So conduct a workshop for stakeholders who will support the effort to develop and launch privacy program, because stakeholders don't have the same level of understanding about the regulatory environment or complexity of that particular understanding. So if you by conducting a privacy workshop, you'll provide an opportunity to ensure that everyone has the same baseline understanding of what risks and challenges the organization faces if we do not protect this personal information or personal data. They also need to understand the data privacy obligation that are imposed on the organization. This organization, ABC Limited, what are some of the privacy obligations that are imposed on it? Are they supposed to adhere to the GDPR? Are they supposed to adhere to the Data Protection Act 2019? So this workshop will come up with that sort of baseline understanding of this aspect. Also, they will need to understand the marketplace expectation regarding the protection of personal information. What is important? What is why is it crucial to protect this personal information? So we have some governance models that you can use within your privacy. If you have a privacy office, that you've established your privacy office, some governance model that you can take into consideration will help you actually make sure that you manage your privacy program successfully. So governance models provide the basis for making of decision by privacy team and policies they need to establish. So positioning the privacy team under corporate legal umbrella may be substantially different from aligning the team under IT umbrella. And this is what I talked about. Because what is the governance like? Now, if we say that within the organization ABC Limited, the issue of privacy, the function of privacy is being taken care of by the legal department. So you see, the guys who are going to look at the privacy function will be more of legal personnel. It is different when it is put under the IT or information security. Then it will be different. So this is why that governance model is important. So it is also important that the executive leadership support the governance model and have a direct, because if they do this, it has a direct impact on the level of success when implementing your strategies. So privacy governance models include centralized, local, and hybrid. So governance models and the choice of the correct model objective should ensure information is controlled and distributed to the right decision makers. So let's look at the centralized. Now, in a centralized governance model, we have one person who is responsible, this is mostly suitable for organizations used to utilizing a single channel function, where the direction flows from one single source, with the planning and decision-making done by one group or one person. So one team or one person is responsible for privacy-related affairs. And in most cases, you'll find that this person is always called the Chief Privacy Officer. Or if it's a group, then we call it Corporate Privacy Office. So they take care of all privacy within the organization. Now, the advantage of this is that it has got streamlined processes and procedures that will allow the organization to create an efficiency by using the same resources throughout the organization. So this centralized sort of governance is advantageous because of the streamlined processes and procedures. It is the best structure as it provides a single person with the authority to make decisions and the accountability for the program's result. I think that is very clear because this single person has got the authority to make decisions, and this single person is accountable for the results of the program. Then we have decentralized governance, in which case this has got the policy of delegating decision-making authority down to the lower level of an organization at a distance from and below a central authority. So we have a central authority there, but they don't actually make decision. The decision is being made at the lower level. This is where you have maybe a global company which has got offices all over, and they say that now the Kenyan affiliates are going to make their own decisions because they are being governed by a different privacy law. So this is where decentralized governance comes in. So it has got fewer tiers in the organization structure, wider span of control, and bottom to top flow of decision making, which means that the decision is made at the bottom level, but they trickle up to the executive. So the top executive delegate much of their decision making to lower tiers of the organization structure. With a fewer layers of management, decentralized managers create and manage their own business practices. So we say that the company in Kenya is part of the company in the global company, but since we have our own privacy laws, we are going to make our decisions which are concerning Kenya company within Kenya. That is local management. So employees are tasked with solving problems which they are closest and more familiar with. Then you can also have a hybrid governance. Hybrid governance allows the combination of centralized and local governance. Here, the organization assigns a main individual or department and the responsibility of privacy-related affairs for the issuing of directives to the rest of the organization. Then the local entities then fulfill and support the policies and directives from the central governing body. Members of the privacy team may sit locally, for example, with regional compliance hubs in large multinationals. So this is the hybrid type of governance. And each region may have a privacy manager who reports to local management, or it may be reporting to the CPO at the global level. So those are some of the governance that you can put in place once you've done your strategy, you've done your scoping, and your privacy program management is in place. So how do you govern it? You can either choose the central type of governance, you can choose the decentralized, or you can choose the hybrid type of governance. Now, let's look at privacy principles. We say that when you are collecting information, you are collecting data from your organization dealing with personal data, then collection of this information must follow the laws and regulation of that particular jurisdiction, and also must also follow some privacy principles. So what are some of these principles? And some of these principles, you'll find that they are enshrined in most data protection laws. Like if you go look at the Kenya, the Data Protection Act 2019, you'll find that these principles are actually enshrined within the Data Protection Act 2019. If you look at the GDPR, you'll find that these principles are enshrined in the GDPR. So these are some of the principles that of data of privacy that most of the legislation around the world are anchored on. So first is the lawfulness, fairness, and transparency. Lawfulness means that personal data must only be processed when the data controllers have got legal ground for processing the data and must be carried out within the limits of applicable laws. So the PII principle, that is the data subject, must consent to the processing of his or her personal data for one or more specific purposes. So there must be a lawfulness when processing that data. And you as a principal, as the data subject, must consent to the processing of that data. And this is enshrined in many of the legislations around the world. Now, the other aspect is the fairness, which means that the processing of personal data must be fair, and PII principle, that is the data subject, must be aware of the fact that their personal data will be processed, including how the data will be collected, kept, used, and allow them to make informed decisions about whether they agree with the such processing or enable them to exercise their data protection rights. Now, the other aspect is the transparency, which means that the data subject or the PII controller must, PII controller is the data controller. It must be open and clear towards the PII principle when processing personal data, when processing his or her personal data. So transparency also requires that information be provided in a timely manner and must be clear, concise, and easy to understand, and that it is provided, it be provided in accessible manner. You remember when you say that if somebody needs his data, then you need to provide that data in accessible manner. There's also the principle of purpose limitation, which says that PII controller must collect and process personal data to accomplish specified, explicit, and legitimate purposes, and not process personal data beyond such purposes, unless the further processing is considered compatible with the purposes for which the personal data was originally collected. So if you're collecting that data or personal data information, you must collect that personal information to accomplish specified, explicit, and legitimate purposes. So organizations should carefully consider what PII they will be collecting to realize the particular purpose before proceeding with the collection. And that is why I say that each and every person within the organization has got a responsibility. The salesperson, when they are collecting data from the clients, they need to make sure that they respect their choice. So organization must be careful when you are collecting that the data that you need is for the purpose that you need it. So organizations should document the type of PII collected and as well as their jurisdiction for doing so as part of their information handling policies and procedures. The other aspect is data minimization, which means that the controllers or the PII controllers must collect and process personal data that is relevant, necessary, and adequate to accomplish the purposes for which it is processed. Now, there are two aspects of the data minimization. Here, we are talking about necessity, which means that the controllers must assess whether the personal data to be collected is suitable and reasonable to accomplish the specific purpose, or if the personal data is of nature necessary to attain the purpose. The other aspect of data minimization is the proportionality, which means that the controllers should consider the amount of data to be collected. From the beginning, before you collect it, you need to consider what is the amount of data that I need to collect. Because collecting large amount of data, which is excessive in relation to the purpose for which you collected it to accomplish that particular aim without restriction will be considered disproportionate. So the data minimization, you only collect the data that is adequate to accomplish the purpose for which you are collecting or processing that data. The other aspect is accuracy. Now, accuracy here, we are talking about data controllers must be able to take reasonable measures to ensure data is accurate, and when necessary, it is kept up to date. Data that is kept by the controller must be accurate, must be kept up to date, and reasonable measures should be understood as implementing processes to prevent inaccuracies during the data collection. That is verifying the data is accurate, complete, and is not misleading, as well as during the processing of that data. So accuracy is an important aspect within, important principle within data privacy principle. Now, the other one is storage limitation, which means that data must be kept for longer. Data must not be kept for longer than necessary for the purposes for which the personal data is processed. So if you collect data and you say that we are going to use this data within 30 days, then after 30 days, you need to delete that data. So because whatever you collected it for, once it is done, then that data should be deleted. So once the information is no longer needed, personal data must be securely deleted. The word here is securely deleted, not just a matter of deletion. It must be made sure that it is securely deleted. Now, the controller must assess whether the personal data is to be used for one or several purposes and limit the processing to a period during which the personal data is needed to accomplish the specific purpose or purposes. So in order to ensure the personal data is not kept longer than necessary, time limits should be established by the controller for erasure and periodic review. integrity and confidentiality is another principle of data of privacy. Now, in integrity and confidentiality, we are talking about personal data must be processed in a manner that ensures appropriate security of personal data, including the protection against unauthorized or unlawful processing and against accidental loss, destruction, damage, using appropriate or technical organization measures. You have to put those technical and organization measures to make sure that that data is protected from unauthorized access or unlawful processing. To protect and preserve personal data throughout its life cycle, the controllers should therefore implement information security framework. And we talked about information security and data security, privacy, they go hand in hand. And to preserve the integrity, confidentiality, and availability of the data, controllers must assign sufficient resources to develop and implement an information security policy framework. The other principle is accountability. Now, accountability means that the organization processing that personal information must have proper policies and procedures to promote proper handling of personal information, and can demonstrate, not only have the policy, but they can be able to demonstrate they have the capacity to comply with the applicable laws. So it's not a matter of just we have the policies to promote proper handling, but you can be able to demonstrate that those policies are working and those policies comply to the applicable laws. So it is not about only saying the organization is taking action, but actually being able to prove that it is taking those actions to protect the data. That is the accountability aspect of privacy. So the organization is accountable for action it takes or does not take to protect that. So if it takes an action, then it's accountable for. If it does not take any action, it's also accountable for why not taking that particular action. So when organizations collect, process, and process information about people, they must be able to be responsible for it. So that is the accountability, which means that if you are an organization which is processing data, like the lawyers, you have a lot of information, personally identifiable information from your clients, you must know that you are responsible for that particular information. And that is what is all about accountability aspect of privacy. If the organization has a policy in place, it should follow the policy or document why it has deviated from following that particular policy. So let's look at privacy versus security. There are certain overlaps when we talk about security and privacy. When we talk about privacy, we are addressing, we are talking about the rights of individual to control and how and to what extent their personally identified information is collected and further processed. Now, when we talk about information security, we are talking about assuring the confidentiality. We talked about confidentiality, keeping the secret, integrity, which means that the accuracy and the completeness of data, and availability of that information, which means that that information is only available to the authorized person. So those two terms, you need to understand them. So when you look at privacy and the security, privacy and security overlap in the following areas. When you talk about integrity, we are talking about, that is mostly information security, and accuracy. We are talking about the data must be accurate. Availability, information security. Access, privacy. Accountability, both of them talk about accountability. Confidentiality is where we are talking about the data is both personal and information and is non-public. So those are the areas where we have the overlaps. And that diagram shows you that you can see that on the The other circle we're talking about information security, where we have the confidential information. And within information security, you have the accuracy and the integrity, authorized access, accountability, and accessibility. When you are talking about personal information, we are talking about the privacy aspect. So what are these overlaps? Information security focus on data integrity, overlaps with the privacy accuracy requirement, in that both target at ensuring data is not altered without authorization. So when we talk about integrity and we talk about accuracy, which means that we are talking about the same thing. Data is not altered without authorization. Information security availability requirements supports the privacy access requirements, because if data is not available, it cannot be accessed. Then we're talking about both information security and privacy doctrines require data owners and custodians to be responsible for protecting the data in accordance with the respective protection regimen, which is form of accountability. Accountability means that whatever you do to the data can be traced. In information security, we normally talk about IAAA, which is the identification, authorization, and accountability. So both talk about accountability when we talk about information security and privacy. And when the information is both non-public and personal information, confidentiality supports privacy, because non-public data should be kept non-public. Some of the disconnect that we can talk about is privacy has a wider set of obligations and responsibility than the security does, because we've just talked about the principles of privacy principles, and we talked about things like collection limitation, openness, relevancy, use or limitation. These are things that are more of privacy than information security. So we know that while information security techniques can be privacy enabling technologies, that is tools that will be able to be used to implement privacy, the privacy enhancing technologies can also become feral, in which means that it can become wild if applied incorrectly, which means that if they are applied in an invasive manner, then they can bring damage to the organization. So what it means that you can have security without privacy. Remember, you can have security. We are dealing with the confidentiality, availability, and integrity of information. So you can have security without privacy, but you cannot have privacy without security, because the security we talked about security. The privacy is about data governance, the way you collect and process that data, and at the same time, it's about protecting that data from unauthorized access. So information privacy and information security are both data protection regimes, and while they have different focuses, they also have significant overlaps. So this seminar or this webinar was mainly focusing on information security and on privacy from the point of from the context of an enterprise. It is not, we do not want to get into other aspects of privacy, like the privacy laws that have been enacted in various jurisdictions, but more of how do you implement privacy program management within the organization to ensure that your data, personally, the identified information is kept is collected and processed in a proper way, and at the same time, they are protected from unauthorized access or damage. Yeah, that brings me to the end of the presentation. If there's any question that I need to attend to. Over to you, Annabelle.
Thank you, Mr. Dinga. We have a few questions. I'll begin with the hand, because it has been raised for a bit. I'm going to request Noel, kindly unmute and ask your question. Noel, I don't know if she forgot or he forgot there. I'll begin with what we have, what I've noted so far. Most people are requesting for your presentation, Mr. Ding. I don't know if you are comfortable sharing it.
That one, I think David will be able to, I'll send it to David, and David, I think, will be able to share it.
Okay, no problem. So the presentation is going to be shared with, if you registered for the session, most likely we have your emails. We will share them via emails. There was also another question in regards to a recording of this call. It's been recorded and it will also be shared in due time. Well, this one is not really a question, it's more so information being shared. I think because we had mentioned earlier that in the East African community, so far it was just Uganda, Kenya, and Burundi that had primary statutes governing data protection and privacy. And we got a few clarifications in the section, in the comment section, saying that Rwanda also has a law on protection of personal data and privacy, which was enacted last year. So we just for clarity, Rwanda also has a law. If there's anyone with a question or two, please. I'm looking through and I am not seeing any questions, just people thanking you for the insightful and informative session. If you have a question, feel free to.
If there are no questions, there are only two things. Either I was not very clear, or everybody understood everything.
We have two questions. I've received two questions. I'm going to begin with the first one. Nelson is asking if we can have data protection assessments in the process of development of African laws, just like we do statutory impact assessments before acts and regulations are passed.
Pardon? If you can have?
Nelson was asking if we can have data protection assessments in the process of development of African laws, just like we do statutory impact assessments before acts and regulations are passed.
Okay, here we are talking about privacy in the context of an enterprise. And what we said first is that before you implement a privacy program, there are two things that you have to take into consideration. The type of data that the organization collects, processes, and then you also look at the laws and regulations that the organization should be able to adhere to. So one thing that you will have to do is on the first aspect of what data is being processed or what information is being collected and processed by the organization, you'll need to do the data assessment. And that is our next topic. So you need to do the data assessment, and so that you have your inventory of the data within the enterprise. So I don't know whether that answers your question.
I think it does. Oh, there is one more question from Henry. is asking what the main difference between privacy and confidentiality is.
Oh, all right. I explained that when you are looking at privacy, or when you are looking at information security, there are two aspects. One, okay, let me start like this way. I said that when you are looking at privacy, there are two aspects of privacy, components of privacy. One is the collection and processing of that data. Is it done properly? Okay. Then they also look at the protection of that data. Now, in the protection of the data, we talked about the confidentiality, the integrity and availability of that particular information or data. When we are talking about confidentiality, there are two aspects of confidentiality. In fact, confidentiality just means keeping the secrets secret. Now, there are two aspects of confidentiality. When that you are protecting confidentiality of data that is relating to a person, then that is what we call privacy. When you are so privacy is when you are talking about confidentiality, but you are talking on personally identified information, personally identifiable information. That is the privacy. So that is how you can differentiate between privacy and the confidentiality, because confidentiality also means secrecy, in the sense that if somebody, an authorized person who is supposed to know to access that data, will be given access to that data. So keeping the secret, which means that only people who are supposed to access that data will be able to access that data. People who are not even supposed to access that data should not be able to access that data, and they should not even know that that data exists. So, and when that data is about personally identifiable information, then it is the issue of privacy kicks in. So confidentiality is an umbrella, and privacy will come inside the confidentiality.
Thank you, Lawrence. There's another question. Nelson wants to know is asking for you to clarify the difference between a data controller and a data processor in simple terms.
Yeah, in simple terms, data controller is the person or an entity who collect that data and determine how that data is processed. For example, your bank is a data controller because they collect your data and they determine what that data can be used. A data processor is a person or entity who collect data on behalf of the data controller, but they don't determine what that data is supposed to do. For example, we have Safaricom. Safaricom is a data controller, but we have Safaricom agents who are agents of Safaricom. They are more of data processors. They don't determine what that data is supposed to be used for. It's the Safaricom that has got that authority. So that is the difference between data controller and data processor.
Okay, thank you. Willie says privacy is a fundamental right. So why does explication, okay, I don't know if it's me or if the statement is phrased, or let me just paraphrase it. I think he wants to know why your explanation is not based on human rights laws and conventions like UDHR and others, your explanation on privacy. He wants to know, because privacy is a fundamental right, at least it appears in most constitutions, He wants to know why explanation is not based on human rights laws and conventions.
I think I explained that privacy is a fundamental right and is enshrined in many international treaties, like International Covenant on Civil Rights and Political Rights, European Convention on Human Rights, European Charter of Fundamental Rights. Yes, it is a fundamental right. However, what we are looking, you remember our presentation here is privacy in the context in an enterprise context. Now, when we talk about privacy, we are talking about physical privacy as well as data privacy. So that is why after explaining, introducing privacy from the context of fundamental rights or constitutional right, I went right into the Kenyan Constitution, Article 31, and I narrowed down to the other aspects which deals mainly with data privacy. So here we were talking about data privacy rather than physical privacy, and that's why maybe I could not use other legal instruments to explain the privacy. Yes.
Thank you, Lawrence. I do not see any other questions on the call, unless someone wants to raise their hand. We have a few minutes.
Still have a few minutes. You can, somebody who can have some other thing.
Yes. I see some in the Q&A. Okay, Amos Mwine is asking, do you have any experience with Ugandan legal framework to do with data? And if so, how is it different from Kenyan laws?
No, for Uganda, I don't have experience. For Kenya also, you know, Kenya just enacted our Data Protection Act 2019, and we are in the process of even putting up the data, the ODPC. Things are still in their infancy. As you know, this is a new area. This is a new area, and as you know, the technology even moves faster than legislation. So, in short, I don't have experience in with the Ugandan Ugandan context, and in Kenyan context also, we are still at our infancy. And what I can say is something that is coming up, very rapidly, and we find that technology, being that the technology is moving faster than legislation, we find that there are certain things that technology wants to accomplish, which needs legislation. For example, I'll just give you an example. In banking sector right now, there's what we call open banking. Now in Europe, the European Union came up with what we call the PSD2 regulation, which which requires banks to share information regarding the consumers to other third party. Now, which means that sometimes I'm a customer in the bank, and I need my personal information for me to access some financial facility. Then the bank should be able to give that information by using through my consent to a third party. But you see, for that to be done, it has to be anchored in law. And what is the law that we have? We have the Data Protection Act 2019. And within that data protection, the Act 2019, you need to do a regulation that is focusing on how the banks can be able to share the consumer data with a third party. So there's, as I can say, we are still at infancy, but these are things that are real. These are things that are we'll have to experience and see how we can go about them. In a nutshell, yeah, Uganda, no experience, but I think it's the data protection is modeled on the GDPR. Most of them are modeled on GDPR.
Thank you, Lawrence. I have some more for you. Someone is asking, how can a customer accessing a website, for example, be sure that his personal data will actually be subject to what you called storage limitation?
Now, that is a problem, because one thing is that there's what we call cookies, right? Cookies, I think, is a technology which monitors your browsing habits, and then gives you targeted advertisements. So you find that in many organizations, they have their websites, and they have put cookies which are tracking you, and you don't actually know. So that is why with the data protection and the GDPR, that must right now, that must be put transparently. So when you visit our website, then nowadays you'll see that this website is using cookies, and they can even tell you the type of cookies that they are using. Then they decide that you decide whether to accept those cookies or not. Okay, so that you be able to access the website. So those are things that are now taking place with the enactment of the GDPR, and you can see many organizations are now seeking consent for them to collect information about you. This is what we call consent management within the privacy field.
We have another question from Henry, although it's not very clear, but I hope I'll paraphrase and the question, I get the context of the question. He's asking what the interest of an organization would be to collect personal data. I think he wants to know what reasons would an organization collect personal data for?
If you go to a bank, why do they collect personal data? Because they want to give you a service. If you go to a hospital, why do they collect the personal data? Because they want to give you a service, and they want also to see if you are a patient, how you progress with the treatment. So there are various reasons that why an organization can be able to collect personal data. When you are being employed within an organization, they have to collect personal information. That's personal data. So I think there's numerous reasons why organization may want to collect personal data, which we can't just list all of them here, depending on the organization that is collecting that personal data.
I have another question. Under what circumstances can the government machinery intervene in data privacy?
Government to intervene in data privacy, you see, data privacy is not a function of the government, because government is just an entity like any other entity, and government may also want to collect the data. For example, if you look at what we had here, Huduma Kenya, where the data was being collected, And then after a collection, then somebody went to court and said that the data was being collected illegally. Okay, then that is what prompted the Data Protection Act to be enacted. So I can say that the government is interested in collecting personal data, but rather the government is just an entity which might be interested in collecting the personal data for the provision of services. So like Huduma number is we are talking about Kenyans doing away with the IDs and using the Huduma number for integrated service provision. So those are some of the reasons why the government might be interested in collecting the data, personal data, so that when you have Huduma card, how it is supposed to work, you have a Huduma card, then you'll be able to access the services, all the government services, from one single identity or form of identity. So I don't know whether that answers your question.
I think that answers the question. Maybe if it's okay if I can add to that. He was asking under what circumstances the government machinery can intervene. I want to believe he means maybe the regulator that would be in charge of this. The circumstance would be that, like Lawrence has mentioned, most of our constitutions, especially ones that have primary laws for personal data and protection and privacy, have effect the right provided for in the constitution. For Uganda, it's Article 27, if I'm mistaken, that provides for the right of privacy. No, Article 31, and the primary law for data protection and privacy gives effect to that right, which is the Data Protection and Privacy Act of 2019. It was also enacted in 2019, like the Kenyan one, and that the regulator in charge of ensuring compliance of that act is the Personal Data Protection Office. So I think it's to that extent that government intervenes with data privacy, because the Constitution provides for that right, to effect laws to that effect, and a regulator to manage such laws. We are running out of time. We have about 3 minutes. I don't see any other questions.
Okay.
There is one. Can privacy really be observed in a couple? I don't understand what that question means or requires. I think that's it from our end. For those that have been asking because I see a lot of messages asking for the presentation, it's going to be provided, and so it's the recording for this.
Annabelle, there is more one question.
Okay.
This Christian is asking, as an enterprise, do you prepare the data privacy management system together with the strategic plan of an enterprise? Then there is also another question here by the same person, Christian. How do I stop the enterprise? How do I stop the enterprises who use cookies to track me after I have accepted when I visited the site, and I do not want the adverts?
I think when you go to our website, what you need to know is you first of all read and understand the cookies, what the cookies are doing, and also understand what is the exit clause where within when you when you don't want to be tracked. Those should come very clearly, because that comes under consent management. So within you go to our website, they tell you that they use the cookies, there's always an option of which cookies are acceptable to you, and or the option of which cookies are not acceptable to you. So you choose which cookies that you want enable, and within that they should also be able to tell you when you can be able to stop those cookies from tracking you. So if that clause is not there, then consent management within that website is not properly done. So it is only, they should be able to give you opt-in and opt-out when you're using that particular website. The other question was regarding, can you come on, the enterprise end?
The other question was, as an enterprise, do you prepare the data privacy management system together with the strategic plan of an enterprise?
Now, I talked about privacy program management, and I said privacy program management, what you start with is vision and mission of that particular privacy management. Now, and that particular privacy management vision must be in alignment with the vision and mission of the organization. So it is anchored on the vision and mission of the organization that brings forth the privacy management. So when you're looking at the strategic preparing the strategic strategy of the organization, just have in mind that when you want to do the privacy management, then it will be part and parcel of that. The vision and mission will be part and parcel of the strategy of the organization. So strategic at the enterprise level is higher than the privacy management framework or privacy management program, which is coming lower than lower than the strategy of the organization.
Lawrence, there are two more questions. What would you say about governments collecting citizens' data for the purpose of security without observing all the principles that you stated and named, i.e. lawfulness, fairness, transparency?
Now, in any data protection law, there will be a clause. There will be a clause where there's exemption when you are collecting personal data without the consent. For example, if it is a criminal matter, then the police or the security organs can be able to collect that data without your permission because they are doing investigation on a criminal matter. So those are the instances where the government will intervene without your consent and will be able to collect that data. And that is clearly enshrined in the data protection or the legislation of a particular jurisdiction. Under what circumstances can the government intervene and collect the data without your consent?
There's one more question. Africa, through the Malabo Protocol on Privacy on ICT Environment, has its own convention, but most of the multinational SIEs from Western SIEs obey to the EU Data Protection Convention. According to you, are common clause views between the two conventions? I think it's asking whether there are common views between the two conventions on sharing data between multinationals in Africa and their headquarters in Western countries.
The Malabo Convention is an AU project, okay, and which was supposed to allow countries within the African countries to share their data transparently. I've not gone very much into details on the Malabo Convention, But what you'll find that Malabo Convention and the EU, the GDPR, the models are, or the frameworks are almost similar or the same in many aspects. So you can subscribe to Malabo Convention because it's an AU project, which is, I think, I don't know how many countries have signed the convention, but at the same time, the GDPR depends on how, on the type of the data and what the type of people whose data you are processing. So if you are processing people data for personal data of people from the UE, from the EU, then you need to adhere to the GDPR. But when you look at them, even though I've not gone through Malabo Convention in details, but you'll find that almost they have a lot of similarities.
Okay, I think this is going to be our last one. What role can the judge play in the protection of private data?
What role
can a judge play in the protection of personal data? I think that is what he meant by private data.
A judge? I don't understand, because I don't see how the role of a judge, because all the data protection, the personal data is governed by legislation. Yes. And the judge is there to just adjudicate according to the legislation. So I don't know how they can play a role except for the adjudication of according to the legal framework that is there. I don't know. I don't understand that question into detail.
No, I agree. According to his question, that would be the right answer. That's the only, that's the point at which a judge comes in. Otherwise, there are regulators for these laws.
Yeah.
The judge would just adjudicate and just make sure that's really as far as it can go. And we do not have any other questions left, so I am going to thank our guest speaker for the day, Mr. Lawrence Dinga, for your presentation. It was very in-depth and thorough, and we're truly grateful. We hope to be able to host you more, because like you said earlier, this is just the surface of it all. Didn't really go into the personal data, data protection aspect of it and the laws therein. So we hope that we can have more, we see more of you and get more of your insight on the same. I don't know if David has any communication he would want to pass on before we close. I don't think so. I have one though. This was the part one of the 3 sessions to do with private data, and the other 2 are happening. The other 2 will happen. The second part will be on privacy governance, which will be on the 21st of January, 2022 from 3 to 5. And the third part, which will also be the final part, will be on data assessment, which will happen on the 25th of January from 2 to 4. So everyone that will attend all 3 sessions will be able to get a certificate of attendance for this entire workshop. That being said, thank you again, Mr. Dinga, for today. And I think we can close the session now. Thank you everyone for attending. We attended in large numbers. We are truly grateful and hope to see you the next time.
Thank you. Bye-bye.
Bye-bye. Have a good evening.
Same to you all.
Thank you. Bye.